Hello, everyone. This is Larry Vernaglia from Foley and Lardner. Good morning or good afternoon, and thank you for joining us for this 30-minute quick discussion about some important developments relating to the final rule for the 60-day overpayment or refund rule for Medicare purposes. With me today is my colleague Heidi Sorensen from our Washington, D.C. office, and together we're going to walk you through some of the highlights of this regulatory development. We are recording today's program. We will keep it to 30 minutes. We may have included more material in the slides than we will cover, but we hope that'll be useful for you as you review it. Also, if you're a subscriber to our blog, healthcarelawtoday.com, you can go on there for some additional information, which we will update from time to time. So what we are planning to cover in the next 30 minutes is what CMS did on their publication last Friday, February 12th, in the Federal Register, which is the final rule on the 60-day overpayment or refund rule. It has been published now. It is effective as of March 14th, so the day before the Ides of March, and we now have about a month to get ready for it. This is not exactly our top 10 list, but maybe our top 6 or 8 things that we thought you would want to know and at least consider it your cheat sheet. The things that we would say are the big takeaways here would include, first, CMS talking about a 6-year look back for overpayment refunds on a voluntary basis and outside the False Claims Act, as opposed to what we have always used before, which is the 4-year reopening period, so shorter than others. We'll talk about what CMS has said in terms of how an overpayment must be identified before the clock starts running, the 60-day clock. That includes concepts such as reasonable diligence, the obligation to quantify the overpayment, and a period of time for that investigation. We'll discuss the refund process, look a little bit at what happens with overpayments and the concept of equitable offset, and then, if we have time, some other commentary which is in this rule, and there's quite a bit in here for those who've been following it closely. I think the background probably ought to be familiar to all of you. This is a rule that derives from a couple of changes in the Medicare Act, not the least of which was from the Affordable Care Act, Section 6402, which is the statutory requirement to return and report overpayments within 60 days of the date they are identified or the date the corresponding cost report is due. And Heidi, in a moment, will take us through some of those provisions. We have, from the regulation, we had a proposed rule that came out in February of 2012, which we then spent a few years thinking about. We saw that CMS published a final rule for Medicare Part D and C plans in 2014. This is not a rule about the duty of a provider to refund to those plans. Rather, it's the obligations of those plans to make refunds of overpayments they may receive from Medicare. Finally, and what we'll talk about today is our final rule on Medicare overpayments. We've given you the regulatory site there if you want to pull it down and read it for yourself. And we note that there is no final federal rule for Medicaid overpayments, but we have a number of states that have issued their own policies about how those states want to see the statutory provision implemented. Now, I noticed in the last slide that the proposed rule came out in 2012. Why did it take so long to do this? In 2015, when CMS was supposed to have issued their final rule, they asked for a 1 year's delay due to exceptional circumstances. And they noticed in there the complexity of the rule, the significant public policy and operational issues that are around it, and they really wanted to provide what they thought would be clear requirements for everyone. I would also note that there were a few False Claims Act cases that are directly related here that were happening at about the same time, most notably the case in New York related to Kane, which we'll talk about in a little bit. But Heidi, would you like to take us off from here, maybe walk us through what the statute says?
Yes, absolutely. And before I do that, I just want to add that although the rule obviously is complex and significant, the rule itself only takes up parts of 2 pages in the Federal Register, And much of the important information is in the guidance and commentary in the preamble that we're going to discuss today, and that's about another 29 pages. So the rule itself is only 4 sections if anyone's going to go and read that. So what did the ACA require in the first place? It put in place a requirement to report and return overpayments and stated that if someone had received an overpayment, they had to report and return it within 60 days of the date on which it was identified, or the date any corresponding cost report was due. And the identification was not a term that was defined in the Affordable Care Act. So over the last 6 years, as we've waited for this final rule, there's been significant debate about what identifying an overpayment means. The Affordable Care Act section also included enforcement mechanisms, including the ability of the government to use the False Claims Act to enforce this requirement. The rule applied very broadly to providers, suppliers, Medicaid managed care organizations, Medicare Advantage organizations, and also Medicare Part D plan sponsors. And with respect to the specific enforcement mechanisms, the Affordable Care Act created a new civil monetary penalty for failing to report and return a known overpayment within the deadline set forth in the statute. It also included the False Claims Act provisions I mentioned, as well as the Act can be enforced through the OIG's exclusion authority. We're going to move on to the top takeaways, the top issues that we saw. And first and foremost was CMS's decision, as Larry mentioned, to require a 6-year look-back period. The proposed rule had included a 10-year look-back period, and that was based upon the outer limit of the False Claims Act statute of limitations. The basic statute of limitations under the False Claims Act, as everyone is probably aware, is also 6 years, and the statute of limitations under the civil monetary penalty law is 6 years. So this 6-year look-back period is consistent with the False Claims Act and the civil monetary penalty law. But it is longer than the current reopening period, which is 4 years, changing obviously with this promulgation. And it's also longer than the period of time CMS had required providers to review when they submitted a self-referral disclosure protocol submission related to Stark issues.
One of the interesting things here, Heidi, I think, is the effective date. I think you might have been about to mention that.
I was about to mention the effective date, and I think it is significant. This is not retroactive, even though the law has been in effect since 2010 and there's been an obligation since 2010. But these new provisions in the 6-year look-back period go into effect March 14th, and I think we're going to probably debate for the next month how we handle this very short interim period.
I think we are in an important month, quite honestly. In the preamble to the rule, CMS notes that the final rule is not retroactive, and that a couple of things, that means a couple of things. First, if you are a provider or supplier who reported and returned overpayments prior to the effective date of the final rule, which is March 14th, 2016, and then they continue and say, and made a good faith effort to comply with the provisions of the law. Those providers are not expected to have complied with each provision of the final rule. That's the language they chose. They chose their words carefully here. So they didn't say that, they didn't come right out and say that today there's no duty to use a 6-year look back, but that is a reasonable implication of the fact that this is not effective today, particularly where they continued and talked about the obligations under the Stark self-referral protocol, which you mentioned a minute ago, Heidi, and they explicitly said that if you issued a protocol submission, that you don't have to go back for 6 years for those submissions that were filed prior to the effective date of the rule. So at least with respect to SRDP submissions, there's likely an incentive to file soon, like this month. And maybe with respect to other overpayments, because that 6-year look-back period is not effective yet. This may be a window of opportunity that you'll need to carefully consider with your counsel how to navigate. Heidi?
We're going to go ahead and turn now to, what the question that has plagued everyone for the last 6 years, which is, what does it really mean to identify an overpayment? And as I mentioned, it wasn't defined in the Affordable Care Act. So Larry's going to talk about what the final rule does say about this.
Sure. Thanks, Heidi. And I think it says, I'm going to mention at least 4 key issues that relate to this critical topic of what does it mean to have identified an overpayment. And this is probably the one thing that has vexed the compliance and healthcare communities since the statute was enacted. So the first thing it did was dealt with the specific provisions that were in a definition section of the statute, but awkwardly phrased, relating to the actual knowledge or reckless disregard or deliberate ignorance of whether or not an overpayment existed. And it wiped away a lot of those terms. It's clear, though, that CMS isn't just willing to admit that that actual knowledge of the overpayment triggers the identification. It's certainly more than that. But they took out from the regulation the specific references to reckless disregard and deliberate ignorance, which are used under both the proposed rule as well as the False Claims Act and the civil money penalty law. The agency is worried that providers would not undertake compliance exercises such as auditing, monitoring, or other activities in order to avoid finding or identifying an overpayment. They were worried about the so-called ostrich defense. So what it did after it pulled those out of the proposed rule was it formalized a related concept to one that was introduced in the proposed rule at that point called the reasonable inquiry, and it is now called the reasonable diligence standard. And this is the first and most important thing to be aware of. What does reasonable diligence mean? I think that they've taken this and drawn from their proposed rule definition of reasonable inquiry and said this is the process of both the investigation of a problem, the so-called reactive obligation of reasonable diligence, and they've also expanded it to think about the obligation of having a proper and effective compliance program, which would be a proactive reasonable diligence, one that could potentially catch an overpayment. What's most important to me, though, is, and this is the second topic that I wanted to mention, the second big takeaway regarding identification, is that the 60-day clock clearly does not start running now until after the reasonable diligence period had concluded. This is a very important topic because a number of other commenters had started the clock a lot earlier than that. And so when does the 60-day clock start running? For Medicare purposes, under the proposed rule, the 60-day clock does not start running until after the reasonable diligence exercise, that investigation, has concluded. The third item that I wanted to mention is another important issue that the provider community was concerned about, which is, do you have to have quantified the overpayment before you've identified it? And to an auditor or an accountant, the answer would be, of course. How could you possibly refund an amount if you hadn't quantified it? Though a number of folks believed that that was not the case. Well, now CMS has spoken and agreed that the overpayment has not been identified until the amount has been quantified. Because in our view, being able to spot a problem that could have resulted in an overpayment, maybe discover the causes of it, maybe seen a few claims of it, that's important, and that's part of the obligation of a responsible provider to run those down. But you can't make a refund or a report until you've added it up and know how much to refund. And so CMS acknowledged as much in the final rule. The fourth topic is that with respect to this reasonable diligence investigation, how long can it take? And CMS put into the preamble that the reasonable diligence may take at most 6 months, where they anticipate that it'll take at most 6 months from the receipt of credible information absent extraordinary circumstances. And we've quoted this language for you here that comes from the preamble because we think that this is going to become important for a couple of reasons. The first is that CMS is acknowledging that we have a 6-month period that these investigations can take place, which is a heck of a lot better than other interpretations, which were that you only had 60 days to do it. The second important item is that CMS acknowledges that some investigations can't be completed even in 6 months, and they're calling those extraordinary circumstances. And in the preamble, there are a few lines about what it means to have an exceptional circumstance, and one of them is for those that are unusually complex investigations. And they offer one example of that, which is Stark investigations, physician self-referral investigations. They acknowledge that those are unusually complex, and they're right. But that's not an exclusive list. And there may well be other investigations which are going to require a timely, thorough, professional review using outside consultants, auditors, statisticians, clinicians, and lawyers, which can't be concluded within 6 months. So that's an exercise, again, for you and your counsel or you and your other advisors to evaluate when looking at what your reasonable diligence work plan will be. Can it be done in 6 months? That is certainly CMS's strong preference in here. And if you believe that your investigation is going to take more than 6 months, you're urged to do so only because you've determined that it's an extraordinary circumstance, such as an extraordinarily or unusually complex investigation. What the sum of this 6-month rule and the 60-day rule is you now have roughly 8 months from the receipt of your credible information to make your report and your refund. And we get there by 6 months of the reasonable diligence investigation plus 60 days after that identification to make the report and the return. Now, this 8-month period is a departure from the interpretations of some other thoughtful readers of the statute, including the New York State Office of the Medicare Medicaid Inspector General, the Department of Justice, and at least one federal court case which has been closely watched, and that is the Kane and Health First decision, which I mentioned before. Now, in that case, there is a court decision that said that the 60-day clock begins ticking when a provider is put on notice of a potential overpayment rather than the moment when the overpayment is conclusively ascertained. And the court acknowledged that that was a very strict reading that would be potentially unworkable for many providers, but didn't think that there was any way to read the statute differently. I think CMS has disagreed and acknowledged that the identification is the start of the clock running, and you can't have identified unless you conducted a reasonable diligence. And this has been a consistent message from CMS since they issued their proposed rule several years ago. From my perspective, it's a rejection of the Kane standard, although the CMS does not say that in so many words in their preamble. Heidi, now that we know what the rule says, how should providers and suppliers be applying it?
I think the most important thing is that work plan you mentioned, Larry, making sure that you're spelling out a work plan that can meet the deadlines, and if it can't, that you're keeping regular track of how you're moving forward, because the documentation in your file is going to be important to show that you were meeting and intended to meet the obligations and timeframes for identifying an overpayment and returning it. In terms of the particular processes themselves, there are a number of ways that those refunds can be made, and CMS affirms and very carefully set forth the different processes that could be used, because there was quite a bit of commentary after the proposed rule with respect to the requirement to use any particular process, which is standardized processes across federal health care programs. So they specifically indicated that a provider could use a claim adjustment, credit balances, voluntary offsets, or either of the two protocols, the OIG self-disclosure protocol or the CMS self-referral disclosure protocol, and not just the existing voluntary refund process that the Medicare administrative contractors use. One of the other important issues that the final rule addresses is the issue of underpayments. Often when a provider undertakes a review for overpayments, they will find that there were instances also as a result of the review where they were underpaid or claims were not made for services that could have been billed. CMS stated with respect to that issue that they believed it was outside the scope of this rulemaking, and they declined to extend the one-year period to rebill a claim. There were commentators who had suggested that we have a similar period of time for rebilling, similar to the reopening period. CMS specifically said they would not permit offsets of identified overpayments from underpayments from identified overpayments, and that's fairly consistent with what has been at least the OIG's position with respect to netting. And they also said that underpayments have to be resolved under the reopening rules, which are obviously being extended to include that 6-year period.
Although, Heidi, in the context of extrapolations, the underpayment or the correct or correct payments may show their head again or show their face again.
I think that's right. I think that we are definitely going to see that. And I think that it's actually a good lead into some of the other topics that CMS mentioned in the preamble that are worth talking about just briefly while we have time today. One of them is that CMS expects an explanation of the statistical sampling methodology that a provider used, if there was one used. Not that there's a requirement to use one. So if there is any aspect of netting that is incorporated into the statistical sampling methodology, that explanation is going to be provided as part of the report and refund. CMS also said there's no de minimis threshold, meaning that there is no amount that is too small to refund. And so there's an expectation, even with small refunds, that those refunds go ahead and be made, returned to the payers. CMS also issued some specific clarifications on certain situations involving reconciliation under cost reports. If you are a provider who submits cost reports or otherwise reconciles interim payments, it's worth reading those. They did not, however, change the definition of applicable reconciliation in the regulation itself from what had been proposed in the proposed rule. There is also a very interesting discussion of the anti-kickback statute and anti-kickback statute concerns. In particular, CMS said that with respect to the anti-kickback statute, it was their opinion that if there were a provider party who was not party to a kickback arrangement but had submitted claims that had been affected in some way as a result of the kickback, there would not, in CMS's view, necessarily have been a way for that innocent provider to identify the kickback that tainted the claims and would not have identified the overpayment, and the expectation that the overpayment would come from the parties who were the parties to the kickback scheme itself. It's also an interesting discussion where CMS says in the rule that a submission to the self-referral disclosure protocol by CMS's self-referral disclosure protocol or the OIG's self-disclosure protocol told the 60-day period for reporting and returning the overpayment. But other types of disclosures, even to other agencies like the Department of Justice and the Medicaid fraud control units in the states, do not toll that 60-day period. With respect to the administrative burden, we thought it was worthwhile also to mention what CMS's thoughts about what kind of burden this poses on providers. In the proposed rule, they had originally estimated that a provider would return on average 3 to 5 overpayments per year, and it would take approximately 2.5 hours to complete the applicable forms and return it. Well, I think any of us who have ever worked on an overpayment know that was very, very hopeful on their parts. In response to all the commentary about how long it takes to do an overpayment, they raised their estimate to 6 hours, and that may be accurate in terms of completing a voluntary refund form, but I don't think it's very accurate with respect to the amount of time it really takes to evaluate an issue, to identify an overpayment, report and refund, and the number of overpayments that providers typically return per year. The 3 to 5 estimate that CMS had originally used is very, very low.
Certainly not a large organization like a hospital.
Yep.
So our final topic then, Heidi, is what do we do now? In some respects, or in many respects, providers and suppliers have been living under this statute for a number of years. We've not only had 6 years to prepare for the final rule, we've been making refunds and doing the best we can using whatever guidance there was out there, either from Medicaid programs or that proposed rule. I do think, though, that there are a few things that people can take back and start working on now and over the next month. And here's 4 things that we wanted to at least bring to your attention. The first one is, if you have prepared a policy on overpayments and refunds, we recommend that you dust it off and update it for what's new in the final rule. Second, if you have document retention policies that may not be sufficient to accommodate at least the 6-year look-back period, you should make changes to that as well. Whether you have a policy or not, you likely have processes for conducting internal investigations, which I think should have always, or for the last several years anyway, been looked at very closely. This would include, in my mind, new triggers to elevate suspected information that might lead to an overpayment to the right people, making sure that time isn't wasted while knowledge about overpayments hangs around in inboxes and stacks of paper. Rather, it's given to the people who can take advantage of the 6 days, rather the 6 months for the reasonable diligence period. And I think finally, and from my perspective, most importantly, providers and suppliers ought to be training their applicable staff on how to comply with this rule, how to identify, how to spot overpayments, the obligation to bring them to the attention of the right folks within the organization, and just an awareness of what policies you might have out there. For 30 minutes, Heidi, I think we covered what we wanted to. We have a few minutes left for some questions. We have at least one in the queue, although, Heidi, you may have answered that one directly. Did you want to mention it for the other folks on the call?
Yeah, the question we received was how to handle an overpayment due to, I think the question was updated Medicare secondary payer file. One thing to be aware of with respect to the rules is that the rule does specifically in the preamble say that any monies received, including monies received that are secondary, are subject to refund. So if there is a Medicare secondary payer file that is updated and as a result of that there's an overpayment due, I think the answer is that CMS would expect that a refund to be made.
Yep, I agree. It's explicit in their preamble. It makes sense to me too because it's still Medicare dollars. So we have a couple of minutes left then, Heidi, if anyone has a question to put into the question queue, or I forget if there was a way to ask a live question. Maybe the operator will tell us.
If you'd like to ask a telephone question, please press star, then the number 1 on your telephone keypad.
But we are recording this too, so if you do ask a question, don't say who you are. Any questions, operator?
No questions at this time.
All right. Well then, we may have no questions coming in, but people are still digesting this. In many ways, I'm happy that we all had a few years to start thinking about this. There are a few new items in this final rule that are important that you're going to have to get used to. I hope the slides are helpful. I hope our blog is helpful, and please feel free to reach out to Heidi or to me if you have any, or any of your regular Foley and Lardner attorneys if you have any questions about the rule. Thank you for your time today, and enjoy the rest of your morning or afternoon.